During the lecture, I yes, there was one meeting. This is a yeah, we were practicing this. Mediation. After that, eighth year all coming. Must be.
She's a year before. I'm Justice Usha's daughter, by the way. So my mom had practiced when Justice Krishnamoorthy was in the bar record. So I'm the daughter of Justice Sukumar and Justice Usha. And I lost my mom in 2020. She was a prosecuting justice here. So for her memorial lecture, we invited ma'am, and she'd come down in 23 for that. So that's how we have this direct connection with her when she comes. And you feel so great that we meet her. Yeah, she was very, very appreciative of our work here. We've been working since 60 years. Women lawyers group in Kerala. That's a long time.
It was very interesting to see all of you. Very fascinating.
Yes, of course. And we met her again at for the Cancer conference in Toronto. We do a lot of pro bono work along with Cancer, women lawyers.
What's your name?
I'm Karthika Soumen.
I think I met you last time.
Yes, we were all here last time as well. So it's Kerala High Court has always had a family kind of vibes here. So whenever we have the seniors and functions going on, we just get together. So that's the way it is. And we enjoy it. That's how we know about our seniors.
Yeah. Oh, what a lovely way to say it. You know?
Yep, it is. And a pleasure to meet all of you. You're all lawyers, I believe.
No. My son is a lawyer.
Yeah, I remember.
Yeah.
My father was a judge in the Bombay High Court.
Really?
Yeah, Sukumar, way back in 91.
91.
Yes, along with P.D. Desai.
Okay.
It's long back. Yeah. So, it's Kerala Bombay connection.
Malachi.
Yes, sir. I've seen you speaking before in the last year's function. Yes.
Known as Mr. Usha. It's actually very interesting you say this about your high court because it's, it has a family atmosphere. That's something which just from how
The way we interact.
structure is also the building, the architecture, how the spaces are. You get a good vibe.
And actually, we used to have a very relaxed relationship between the bar and the bench. We have a lot of functions happening here. So they also come, they also become part of this. Evenings, music, dance, whatever. So apart from the work part, it's nice. How long have you been in the bar?
I graduated in 2010, so for the last 16 years.
Always been in Bombay?
Yes, always.
Good point. Remember going with dad there? Actually,
Good evening, everyone.
come on.
Thank you for being here and thank you so much. To start our program, I respectfully invite our distinguished guest to kindly grace the dais. Our chief guest, Honorable Justice B.V. Nagarathna, Judge, Supreme Court of India. Honorable Justice Soumen Sen, Chief Justice of High Court of Kerala. Senior Advocate Gopala Krishna Kurup, the learned Advocate General. Advocate Sri Piyush Kottam, President of Kerala High Court Advocates Association. Advocate Sri Roy Chacko, and Sri Balaji K. Murthy. May I request them to kindly take their seats on the dais.
Good evening, ladies and gentlemen. We have gathered here this evening to honor the life and legacy of Justice T.S. Krishnamoorthy Iyer, a jurist whose contributions to the bar and the bench continue to inspire generations. On behalf of the family and well-wishers of Justice T.S. Krishnamoorthy Iyer and the Kerala High Court Advocates Association, we warmly welcome you to this memorial oration. To begin this solemn occasion with the blessings of the God Almighty, I now invite Advocate Kavya Suresh for the prayer song.
കർമ്മഭൂമി തളിരിടുന്ന വർണ്ണമേകിയും നമ്മിൽ വാഴുമാദിനാമം ഇന്നു വാഴ്ത്തിടാം. ഞങ്ങൾ പാടുമീ സ്വരങ്ങൾ കീർത്തനങ്ങളാകണേ. ചോടുവയ്ക്കുമീ പദങ്ങൾ നൃത്തലോലമാകണേ. കുഞ്ഞു വീടിനുൾക്കളങ്ങൾ സ്വർഗമാകണേ. അമ്മ നൽകുമുമ്മ പോലും അമൃതമാകണേ. പൂർണ്ണമീ ചരാചരങ്ങൾ ഗുരുവരങ്ങളാകണേ.
Now I invite Advocate Piyush Kottam, President of Kerala High Court Advocates Association, to deliver the welcome address.
Good evening all. Honorable Justice Pvt Nagarathna, Judge, Honorable Supreme Court of India, Honorable Mr. Justice Soumen, Chief Justice of the Kerala High Court, Sri K. Gopalakrishna, Learned Advocate General, Sri Balaji K. Murthy, Advocate Sri Roy Chako, Honorable Judges of the High Court, former Judges of the Honorable Supreme Court, Honorable High Court, learned senior advocates, my esteemed colleagues at the bar, my young friends, members of the Clerks Association, students from the Law College, family members of Justice T.S. Krishnamoorthy Iyer, ladies and gentlemen. Today, we have assembled to fondly remember and pay tribute to an everlasting and evergreen stalwart of our fraternity, the late Justice T.S. Krishnamoorthy Iyer, and to inaugurate our continuing legal education program and Wednesday Club. Late Justice Krishnamoorthy Iyer was one of the most eminent lawyers of the bar. Recognizing his exceptional caliber and professional brilliance, he was appointed as the Advocate General of Kerala in the year 1965. In the very same year, he was elevated as the High Court Judge of Kerala. He demitted office in 1973. Thereafter, he proved his mettle as a distinguished and celebrated advocate before the Honorable Supreme Court of India. His life and work remain a guiding light and source of inspiration to generation of lawyers and judges alike. We are indeed fortunate and deeply honored to have among us today Honorable Justice B.V. Nagarathna, who has graciously consented to deliver the remembrance lecture and to inaugurate our continuing legal education program. Her Lordship is widely admired for her intellectual independence, courage of conviction, and clarity of thought. She has earned the affectionate sobriquet Iron Lady of the Judiciary. Her judgments reflect fearless constitutional vision and an unwavering commitment to safeguarding constitutional values. We, the members of the Kerala High Court Advocates Association, look forward to hearing her Lordship's enlightening lecture today. We also cherish the hope that her Lordship will, in due course, adorn the high constitutional office of the Chief Justice of India, become the first woman to hold that distinguished position. Madam, on behalf of the Kerala High Court Advocates Association and the family members of Justice Iyer, it is my proud privilege and extend to your Lordships a most cordial and respectful welcome. We welcome you, Madam, to this gathering. We are equally privileged by the gracious presence of Honorable Chief Justice, Mr. Justice Soumen. In a remarkable short span, His Lordship has endeared himself to the member of our bar and earned our affection and confidence. His Lordship has been deeply sensitive to the sentiments of the members of our association and steadfastly committed to the welfare of every member of our fraternity. This sense of guardianship, trust, and support we have received from your Lordship is truly commendable. We remain proudly grateful for your Lordship's effort in strengthening the harmonious relationship between bench and the bar. Sir, I extend your Lordship a warm and respectful welcome to this gathering. We are honored by the presence of Sri K. Gopalakrishna Kurup, Advocate General, one among us, and a constant source of guidance to the bar. Sir, I welcome you to this gathering on behalf of all the members gathered here. We are also privileged to have Sri Balaji K. Murthy, beloved son of Justice T.S. Krishnamoorthy Iyer, whose initiative has been instrumental in organizing this program. I welcome you, sir. Advocate Roy Chaco is one among us. I formally welcome him to this gathering too. Before I conclude, may I briefly introduce two important initiatives being inaugurated today. The first is the Continuing Legal Education Program, a monthly initiative aimed at equipping young members of the bar with evolving legal knowledge and professional skills. The second is the Wednesday Club, inspired by the Friday Club the Supreme Court Bar Association implemented recently. This forum will enable young lawyers to engage with the distinguished members of the bar, bench and bar, and to deliberate upon landmark judgments. We are confident that these initiatives will grow into enduring tradition of our association. I shall not take any more of your time, since we are eagerly awaiting enlightening lecture of Her Lordship, Justice Nagarathna. I welcome each and every one of gathered here to this August gathering. Thank you all.
Thank you, sir. On behalf of everyone who gathered here, I welcome you to this prestigious gathering. Justice T.S. Krishnamoorthy Iyer was a man of many firsts, a mayor of Trivandrum, a member of 8th Law Commission of India, and a towering figure at the Supreme Court Bar. Today, we don't just remember a judge, we honor a legacy of integrity that spanned from the Travancore to the Supreme Court of India. It's my privilege to welcome Advocate Roy Chaco to pay homage to this legal luminary. Welcome, sir.
Honorable Mrs. Justice B.V. Nagarathna, Judge Supreme Court of India, my Lord Chief Justice Soumen, Chief Justice, High Court of Kerala, Sri K. Gopalakrishna Kurup, Advocate General, Sri Balaji K. Murthy, the youngest son of Justice T.S. Krishnamoorthy Iyer, and Mr. Piyush Ekottam, President of the Kerala High Court Advocates Association, Honorable Judges past and present, dignitaries who have come from far and near, senior advocates in the bar, my colleagues in the bar, ladies and gentlemen, family members of Justice T.S. Krishnamoorthy Iyer. Today we are assembled here to pay homage to a great judge, Justice T.S. Krishnamoorthy Iyer, who was not only a great judge, but he had a glorious tradition blended in aristocracy, nobility, and judicial rectitude. He was a legal luminary par excellence. He had an unfailing courtesy towards the members of the bar. He exhibited a rare display of judicial scholarship. And this and much more, he earned the admiration of all in his times. He was an outstanding lawyer of his times. He was born of Justice K. Shankarasubba Iyer and Srimati Shankari. Justice Shankarasubba Iyer, his father was a judge of the Travancore High Court. Justice Iyer enrolled as an advocate in 1935 before independence. He practiced in the Travancore High Court, Travancore Cochin High Court, and the High Court of Kerala. And he shifted to this place on the formation of the state of Kerala on 1st of November 1956. Slowly and steadily, he rose to eminence in the legal profession and was undoubtedly one of the leaders of the bar in those times. I must say that the government of Kerala recognized his merit when he was handpicked to the post of Advocate General in the year 1965. And though his tenure was short as an Advocate General, he brought luster and majesty to the office of the Advocate General. Soon thereafter, in the year 1965, the then Chief Justice M.S. Menon, a great Chief Justice of Kerala, known for his proficiency and I must say one of the longest served Chief Justices of India, I must say, he handpicked Justice Krishnamoorthy Iyer and he wanted him to be on the bench, saying that he was undoubtedly the ablest lawyer. And in fact, he recommended his name to the Ministry of Law, something which was not, it was debating from the convention. He said he should be on my bench because he's a great lawyer. He will be an asset to the judiciary of Kerala, and particularly to the High Court. He was a judge for 8 years. He demitted office in the year 1973. During his judgeship, his office was actuated by professional rectitude, unfailing, that is, courtesy towards the members of the bar. And he exhibited a rare scholarship, judicial acumen, and highest moral standards, highest judicial ethics, which is unparalleled. After retirement from the Kerala High Court, he started his practice in the Supreme Court of India as a senior counsel. Very soon, a great judge, Justice H.R. Khanna, former judge of the Supreme Court of India, one of the greatest judges India has produced, he wanted Justice Krishnamoorthy Iyer to be a part-time member of the Law Commission of India. In his memoirs, Justice Khanna says that is neither roses nor thorns. He has devoted a paragraph in a particular chapter saying that I was impressed by Justice Krishnamoorthy Iyer when he appeared before me on a number of occasions, and I found him to be a very able lawyer, very proficient in law, and that he would be an asset to the Law Commission of India. So he became a part-time member of the Law Commission of India for 3 years. And after the tenure, he again continued his practice in the Supreme Court of India. One judgment which I wanted to tell you while he was a judge, which I forgot to mention, is a judgment relating to a contempt of court matter against the then Chief Minister. It was a criminal contempt. It was a full bench judgment. The main judgment was delivered by the senior judge, Justice P.T. Raman Nair. The second judge was also a very illustrious judge. Kerala has produced Justice K.K. Matthew and Justice T.S. Krishnamoorthy Iyer. The majority judgment was the Chief Minister was guilty of criminal contempt. Justice Matthew delivered a dissenting judgment holding the Chief Minister to be not guilty of contempt. But the beauty of the judgment is, Justice Krishnamoorthy Iyer's judgment begins saying, I agree with my senior brother Raman Nair J. I do not agree with Justice Matthew, but because Justice Matthew has delivered a dissenting judgment, it has become necessary for me to give my reasons in by a separate judgment. So that judgment, according to me, is one of the finest judgments ever delivered by any High Court in India concerning the criminal contempt, the contempt of court. And this judgment was approved by a 3-judge bench of the Supreme Court headed by Chief Justice Hidayatullah. And I may tell the lawyers here that judgment has to be read because it gives so much of volumes regarding the abolition of the contempt jurisdiction, the commentary by leading authors, American view, British view, all the judgments under the sun regarding that particular subject had been referred to in the judgment. That's a very fine classic judgment, and the Supreme Court had approved that, reducing the fine from 1,000 to 50. What I would like to tell you is, as a senior counsel in the Supreme Court, Justice Iyer had briefs from all the states in India. This I personally know. And he was considered to be the best civil lawyer. Judges of the Supreme Court used to ask him questions regarding the civil branch of the law. Even if it is not his case, judges used to ask, Mr. Iyer, what is the legal position regarding this point? So that was the admiration and the respect that was accorded to Justice Krishnamoorthy Iyer by the judges of the Supreme Court. So after when his health was failing, he had to stop practice. We remember a great judge on this day. It is our pride that Justice Iyer was born in Trivandrum. He was a proud son of Kerala. He had a very rich legacy. And it is said that that legacy has to be maintained. One of the lawyers in our bar told me today morning that Justice Krishnamoorthy Iyer's library had been donated to the bar library, his collection of books. And our lawyers are not reading those books are there. That would have been useful. It would be a fitting tribute to Justice Iyer if the young lawyers here who are in the audience go to the first floor of the High Court building, the bar library, and you can research, you can read the autobiography, you can read the biography of great lawyers. That would give you some inspiration. So this particular trait of reading and researching is something very unique that I think we have that reading habit is lost somewhere, and we should continue with that reading habit. Even general reading would be good. I wish to say no more, but I just quote words of Mahatma Gandhi. He said, there is something higher than the courts of justice. It is the court of conscience, and that supersedes all other courts. Ladies and gentlemen, I profusely thank Sri Balaji K. Murthy, the youngest son of Krishnamoorthy Iyer, who spared no effort to organize this function, and I personally know that his untiring efforts have borne fruit. Today, there are quite a large number of advocates present here. I take this opportunity to express my gratitude to Balaji K. Murthy and all the family members of Justice Krishnamoorthy Iyer, with whose family, my family, share a bonding. Ladies and gentlemen, Thank you so much for patient hearing. Thank you. Jai Hind.
Thank you, sir. Now I invite Senior Advocate Gopalakrishna Kurupa, the Learned Advocate General of Kerala, to offer his felicitations.
Honorable Justice B.V. Nagarathna, Judge, Supreme Court of India, Honorable the Chief Justice of the High Court of Kerala, Mr. Soumen, Honorable Judges of the High Court of Kerala, Honorable former Judges of the Supreme Court, Honorable former Judges of this Honorable Court, Advocate Piyush Kottam, President Kerala High Court Advocates Association, Advocate Roy Chako, Sri Balaji Krishnamoorthy, Senior Advocates, esteemed fellow members of the bar, family members, colleagues, friends and well-wishers of late Justice T.S. Krishnamoorthy Ayya, ladies and gentlemen. It's a singular honor and profound privilege for me in being invited once again to offer my felicitations in the oration in reverent memory of late Justice T.S. Krishnamoorthy Ayya, a luminary whose name stands eternally enshrined in the grand annals of our legal heritage. His life was a testament to intellectual brilliance, unwavering integrity, and selfless public service. A lawyer of exceptional distinction, he adorned the bar with rare erudition and moral courage. As Advocate General, he held the bar of the state with commanding authority and exemplary grace. Elevated to the bench of this honorable court, he dispensed justice with luminous clarity, profound scholarship, and a steadfast commitment to constitutional values. His public spirit found further expression in his stewardship earlier as the popular mayor of the capital city, in his thoughtful contribution subsequently as member of the Law Commission, and in his enduring dedication to education as a committed and visionary educationist. Born in the erstwhile princely state of Travancore into a distinguished lineage of administrators and juries, he inherited a proud legal legacy. Yet in the noble discipline of law, inheritance alone is never sufficient. Justice T.S. Krishnamurthy Iyer did not rest upon ancestral distinction. He refined and chiseled his craft through relentless industry, intellectual rigor, and unwavering dedication, ascending to heights that were truly unparalleled. I had witnessed his extraordinary legal acumen at close quarters when I had occasion to instruct him in matters before Supreme Court. I respectfully pay my obeisance to the memory of late Justice T.S. Krishnamurthy Iyer. The Constitution of India marked the transformation of Indian people from subjects of a royal monarchy into free citizens of a sovereign, socialist, secular, democratic republic. It ushered in not merely a political transformation, but a profound social transformation as well, empowering all citizens equally, Part 3 of our Constitution. Inter alia represents the path-breaking initiative in this regard, embodying the transformative vision of our constitutional framers. This transformative vision, according to me, constitutes the very essence of transformative constitutionalism. The basic structure doctrine, though subjected to in recent times to purposive criticism as a purported impediment to so-called constitutional development, in my view, serves as a vanguard of the original transformative vision of our founding fathers, who were visionaries with far-sighted dreams of building a nation that embraces religious, linguistic, and other diversities. Today, we are privileged to have Justice P.V. Nagarathna, Judge of Supreme Court of India, a jurist par excellence, and an eloquent public speaker, to enlighten us on the topic of transformative constitutionalism and the basic structure doctrine. Refresher courses are essential for members of the legal profession in an era characterized by a rapidly evolving and dynamic legal landscape. Such programs enable lawyers to stay abreast of the latest developments in law and judicial pronouncements. The Honorable Supreme Court has time and again underscored the importance of periodic training programs for members of the bar. I am confident that continuing legal education program being inaugurated today will greatly benefit the High Court bar, particularly its younger members. I am informed that Wednesday Club being inaugurated today will conduct debates and reviews on landmark judgments. Such brainstorming sessions will undoubtedly enhance the vibrancy of this erudite bar. I hope that it will, in due course, attain the stature of the renowned Friday Club deliberations at the Supreme Court bar. This august gathering, eagerly awaiting the address of my Ladyship, Honorable Justice Pvt Nagarathna, and it would not be appropriate for me to detain you any longer. I am certain that my Ladyship will illuminate this evening with her insightful lecture. I once again express my heartfelt gratitude to the organizers for affording me the opportunity to speak on this occasion, and I warmly felicitate them for organizing this distinguished function. Jai Hind. Thank you.
Thank you, sir. Now I request our distinguished dignitaries on the dais to kindly light the ceremonial lamp and formally inaugurate the continuing legal education program and the Wednesday Club of Kerala High Court Advocates Association. Thank you, everyone, and please be seated. As we move further into this evening's program, we are reminded of the profound words of the legendary Sri Fali S. Nariman. He famously remarked that, as long as you are in practice, you are a student of law for life. Believing that the very moment a lawyer stops being a student, they cease to be a lawyer in the truest sense. It is in the spirit of perpetual learning that Kerala High Court Advocates Association today introduces the Wednesday Club and the continuing legal education program. The Wednesday Club is envisioned as a space for mentorship and intellectual dialogue, a commitment to our collective professional evolution. I now most respectfully invite Honorable Justice Soumen Sen, Chief Justice of High Court of Kerala, to deliver the presidential address and formally inaugurate the Wednesday Club. Please, sir.
Honorable Justice Pvt Nagarathna, Judge Supreme Court of India, my esteemed brother and sister judges of this court, Honorable Justice Sri Joseph, former Judge, Supreme Court of India, who is present amongst us. Sri K. Gopala Krishna Kuru, Learned Advocate General. Sri Piyush K. Kattam, President, Kerala High Court Advocates Association. Sri Roy Kako, Advocate, High Court of Kerala. Advocate Srimati Nima Jacob, Secretary, Kerala High Court Advocates Association. Sri Balaji K. Murthy, the illustrious son of Justice Krishnamoorthy Iyer and family members of late Justice Krishnamoorthy Iyer. Senior and junior members of the Bar, Registrar General and the members of the Registry, ladies and gentlemen. Good evening to all of you. It is both a privilege and a profound honor to address this distinguished gathering on the occasion of the second memorial oration in the memory of Justice T.S. Krishnamoorthy Iyer, a jurist whose life and work exemplified the highest traditions of the bar, the bench, and the public service. His unwavering commitment to justice, integrity, and constitutional values continues to illuminate the path of our legal system and to inspire generations of lawyers, judges, and citizens alike. As we assemble today to reflect upon his enduring legacy, we are privileged and eagerly waiting to hear to a constitutional discourse by Honorable Mr. Justice P.V. Nagarathna, Judge of the Honorable Supreme Court, a discourse that promises to deepen our understanding of law and its vital role in sustaining our constitutional democracy. A memorial lecture is not an exercise in nostalgia. It is rather an act of continuity. It invites us to revisit the ideas, ideals, and institutional values that shaped a jurist's life and to reflect upon their enduring relevance to our constitutional present and future. Before turning to the theme of this lecture, I consider it my solemn duty to pay tribute, respectful tribute to the memory of Justice Krishnamoorthy Iyer, an exceptional judge of this court and a luminous presence in the legal firmament of our nation. Born on 4th June 1911 in Thiruvananthapuram, Justice Krishnamoorthy Iyer hailed from a distinguished lineage of judges and administrators. His father, Justice K. Sankara Subbiyar, served as a judge of the erstwhile Travancore High Court. His younger brother, Justice S. Padmanabhan, adorned the bench of Madras High Court, while his nephew, Justice S. Sankara Subban, served as a judge of this court. The family's legacy extends further back to his great-grandfather, Sri S. Sugakra Subiyar, a companion of the most eminent order of the Indian Empire, which is a chivalric honor conferred by the British Crown in the olden days to officials and civilians in recognition of their service to India. He was an eminent administrator serving as the Diwan of Travancore under His Highness Sri Mulam Thirumal. Yet Justice Krishnamoorthy Iyer was never merely an inheritor of legacy. He was its conscientious custodian and creative enlarger. After obtaining his law degree from the Government Law College, Thiruvananthapuram, he began practice in 1935 and rose rapidly to prominence at the Travancore High Court and later at the Kerala High Court at Kochi. His appointment as Advocate General of Kerala in 1965, followed by his elevation as a judge of this court the same year, was a recognition of his clarity of thought, balance, and unwavering institutional fidelity. He served with distinction till his retirement in 1973, mentoring generations of lawyers and judges. It is noteworthy that Sri P.C. Kako, who is present amongst us, Senior Advocate of the Kerala High Court, and Justice P. Krishnamurthy began their legal career as juniors under Justice T.S. Krishnamurthy Iyer. For Justice Iyer, retirement did not mark a withdrawal from public life. He established a formidable practice as a senior counsel before the Honorable Supreme Court, where he was recognized for his constitutional scholarship and integrity. His expertise and constitutional vision led to his invitation by Justice H.R. Khanna to serve as a member of the 8th Law Commission of India from 1977 to 1979. His commitment to constitutional morality and the cause of the poor and dispossessed remains an indelible part of our legal heritage. To speak in his memory is not an act of institutional remembrance, it is an affirmation of the values he stood for. Beyond the courtroom, Justice Iyer exemplified civic responsibility. He served 2 terms as the mayor of Thiruvananthapuram and was the founder chairman of the Bharatiya Vidya Bhavan Kochi, reflecting his belief that law, governance, education, and culture are interconnected instruments in social progress. I'm informed that in 1997, Justice Iyer generously donated his treasured law library to the Kerala High Court Advocates Association, a gesture for which the legal fraternity remains deeply grateful and indebted. He passed away on 3rd September 1999, leaving behind not merely judgments, but a model of public life anchored in constitutional morality, institutional integrity, and ethical restraint. Judges who have worn many robes bring with them a rare depth of experience, wisdom, and perspective acquired through long and varied service to law. Such richness strengthens the institution and leaves an enduring imprint on the society. In recalling his distinguished service, we are reminded of our collective responsibility to reaffirm with renewed conviction our commitment to the ideals of justice, integrity, and constitutional fidelity that Justice Iyer so steadfastly upheld. In an era marked by rapid change and increasingly complex constitutional challenges, the foundational values of justice, fairness, equality, and judicial independence remain not merely relevant, but indispensable. Justice Krishnamoorthy Iyer belonged to a generation that witnessed the Constitution's journey from text to practice. His career reflected a deep and abiding belief that constitutional law is not merely a body of doctrine, but a solemn duty. He understood that while the Constitution finds expression through institutions, it ultimately endures through values. This mentioned oration is therefore not merely a tribute to his memory, it is a continuation of the constitutional dialogue to which he devoted his life. It is thus profoundly fitting that this memorial oration engages with the theme Transformative Constitutionalism and the basic structure Doctrine, a dialogue between change and continuity, between aspiration and limitation, and between democratic majorities and constitutional constraints. A constitution is framed for ages to come and is designed to approach immortality as nearly as human institutions can approach it. Its course cannot always be tranquil. It embodies and expresses the goals and aspirations of the people, shaped by the historical experiences of the society it governs. Every constitution has multiple aspects. It is first a historical product. Secondly, it reflects the political, economic, and sociological philosophy of the makers. Thirdly, it functions as an instrument of good governance, seeking to harmonize the diverse political forces operating within the body politic. The fourth aspect is its legal character, with which we are primarily concerned. This aspect is what empowers the courts to exercise the power of judicial review. The Constitution of India is one of the most comprehensive and well-drafted documents, shaped by remarkably wise, articulate, and erudite pantheon of persons of outstanding ability and vision, with the active engagement of ordinary people with the Constitution's sensibility, like one Koturam from the northwest frontier province, who wrote to the Constituent Assembly welcoming the abolition of untouchability. While it draws from diverse sources, including the Government of India Act 1935, it remains a unique document. Transformative constitutionalism is an idealistic approach to achieve specified goals by protecting the fundamental rights and opportunities of the people. The judiciary is a crucial aspect of the transformative constitutionalism, since the ideology embeds religion in the law as a tool for social and political change, and the courts act as a catalyst for the change because they are sworn to interpret and administer the law. Transformative constitutionalism entails instilling principles such as equality, liberty, fraternity, and dignity into society. It also entails achieving the Constitution's primary goal of transforming society for the better. It envisions our Constitution not as a static document, but as a living instrument through which we strive to realize a just, humane, and equitable social order. It embodies a belief that law must not reflect society as it exists, but guide it towards justice as it ought to be. By interpreting the Constitution in such a way that more and more societal interests are served, the Supreme Court plays an essential role in balancing societal interest with social changes. As Dr. B.R. Ambedkar so presently reminded us, political democracy cannot endure without social and economic democracy. The Honorable Supreme Court has served as a consistent engine of this transformative vision from Maneka Gandhi, Vishaka, Puttaswamy, The Honorable Supreme Court has not merely interpreted the constitutional provisions, it has infused them with substantive meaning, expanded their reach, and in doing so transformed the lives of millions. In recent decades, courts have expanded constitutional rights in response to evolving social realities. The right to privacy has been recognized as intrinsic to personal liberty, digital freedoms, informational autonomy, and democratic transparency have been affirmed as essential to constitutional governance. Courts have also emphasized institutional accountability, electoral fairness, and the importance of an informed citizenry. In each of these instances, transformation has proceeded within the structural limits. Courts have consistently reiterated that constitutional change must respect foundational principles such as democracy, federal balance, and the rule of law. This is the essence of Indian constitutionalism, a constitution that evolves yet remains anchored, a constitutional order that reforms yet preserves its moral core. Yet precisely because the constitution is such a potent instrument of change, there arises the question who guards the constitution. That question is found in answer to the Keshavananda Bharati versus State of Kerala, wherein 13 judges in the historic 7-6 majority decision propounded the basic structure doctrine of constitution, which holds as certain fundamental features of the constitution, such as democracy, secularism, federalism, supremacy of the constitution, and the rule of law cannot be amended or abrogated by the parliament. The court also has held that the power of judicial review is an integral part of the basic structure of the constitution and cannot be taken away by parliament through constitutional amendments. The parliament, all that it says was that the parliament could not use its amending power under Article 368 to damage, emasculate, destroy, and abrogate or change or alter the basic structure or framework of the constitution. Specific appreciation must be accorded to Justice H.R. Khanna, whose judgment tilted the balance. While he rejected the theory of implied limitations based on natural rights, he held that the word amendment implies the retention of the original structure. The conceptualization of basic structure doctrine constitutes the most significant contribution of the Indian judiciary to global constitutional theory. It posits that while Parliament possesses the power of amendment, it lacks the power to destroy the essential identity of the Constitution. These doctrines are not in contradiction, they are complementary. Transformative constitutionalism gives the Constitution its purpose, while the basic structure doctrine secures that purpose with permanence. India today confronts challenges that the framers could scarcely have anticipated: digital governance, environmental crisis, social inequalities in new forms, and questions of identity and representation. The state of Kerala functioned as a jurisprudential laboratory where the collision of radical land reforms with fundamental rights necessitated the birth of the basic structure doctrine. Furthermore, the unique Kerala legal tradition, characterized by the dominance of equity over form, produced jurists like Justice V.R. Krishnamoorthy and Justice K.K. Mathur, who redefined the relationship between the state and the citizen. The trajectory of Indian constitutionalism from the rigid formalism of Shankari Prasad to the dynamic basic structure of Keshavananda and finally the property jurisprudence of the PIL era represents a triumph of judicial statesmanship. The Kerala legal tradition, with its unique blend of social reformist history and high literacy, acted as a catalyst for this national transformation. We are privileged here today to have with us Honorable Mrs. Justice P.V. Nagarathna, a jurist of remarkable moral courage and intellectual rigor, whose career embodies the belief that dissent is not discord, but the essence of a vibrant democracy. Justice Nagarathna carries forward the great humanist tradition of Justice V.R. Krishnamoorthy, demonstrating that the Constitution belongs to we the people, including the most marginalized. Through this memorial lecture, we reaffirm our commitment to constitutional morality, a commitment inspired by life and work of Justice T.S. Krishnamoorthy. It also gives me immense pleasure to formally inaugurate the Wednesday Club of the Kerala High Court Advocates Association. The club is an academic initiative envisaged as a weekly forum convening every Wednesday to deliberate upon a selected legal topic of contemporary relevance. Modeled on the Friday Club of the Honorable Supreme Court, it seeks to promote continuous learning and encourage regular discussion on legal issues amongst the members of the bar. I am confident that the Wednesday Club, alongside the memorial oration, will continue to serve as a distinguished platform for professional engagement, meaningful dialogue, and the promotion of constitutional values for the years to come. Thank you, Jai Hind.
Thank you, my Lord, the Chief Justice, for the presidential address. Your Lordship's words have enriched this occasion. It is now my distinct honor to introduce our chief guest for this evening, Honorable Justice B.V. Nagarathna, Judge of the Supreme Court of India. Her Ladyship's journey at the bar and on the bench reflects a deep and unwavering commitment to constitutional values. Her jurisprudence consistently reminds us that our Constitution is not merely a legal text, but a living instrument. Through her scholarship, clarity of thought, and steadfast emphasis on constitutional morality, her Lordship has enriched the discourse on rights, governance, and the enduring strength of the basic structure doctrine. Ladies and gentlemen, we are truly privileged to have our Ladyship with us this evening. I now respectfully invite Honorable Justice B.V. Nagarathna to deliver the Justice T.S. Krishnamoorthy Iyer Memorial Oration and to formally inaugurate the continuing legal education program of the Kerala High Court Advocates Association.
Namaskar and a very good evening to you all. Honorable Justice Soumen Sen, Chief Justice of High Court of Kerala, my esteemed brother and sister judges of the High Court of Kerala and also a brother judge from Madhya Pradesh, Justice K.M. Joseph, my esteemed former colleague, and Justice Syriac Joseph, I think he thought of Justice Anna Chandy and Justice Fatima Bibi when he recommended my name to the Karnataka High Court. Learned Advocate General Sri Gopal Krishna Kurup, members of the family of Justice T.S. Krishnamoorthy, Sri Iyer, Sri Balaji Murthy and Srimati Usha, Advocate Sri Piyush Kottam, President Kerala High Court Advocates Association and other office bearers, Advocate Roy Chako, who has given the felicitation today, learned senior advocates and members of the bar. I see learned senior advocates from Delhi as well as from Kerala, distinguished invitees, members of the media, ladies and gentlemen. I must thank Mr. Balaji Murthy and Srimati Usha and their family for inviting me to deliver this second Krishnamoorthy Iyer Memorial Oration today. I begin by paying my tribute to Justice T.S. Krishnamoorthy Iyer, an eminent judge who dedicated his life to upholding justice and equality. Born on 14 June 1911 at Trivandrum, he began his career as an advocate in 1935 and practiced in the Travancore High Court in Trivandrum and later the Kerala High Court in Kochi for several years. In 1965, he was appointed the Advocate General for the Government of Kerala, which soon thereafter was followed by his elevation as a judge of the Kerala High Court in the same year. During his tenure as a judge, Justice Iyer earned a reputation of being fair, impartial, and committed to upholding the rule of law. We have just heard speaker after speaker telling us about it. Following his retirement, Justice Iyer established a thriving practice as a senior counsel in the Supreme Court, and he appeared in many landmark cases. He appeared in Mithilesh Kumar versus R. Venkatraman, where the presidential election of Mr. R. Venkatraman was challenged. And incidentally, I must say that matter was before my father, Justice E.S. Venkatramaya, because 5 judges are supposed to hear a challenge to a presidential election. And he succeeded there. Kerala Hotel and Restaurant Association versus State of Kerala, Union of India versus K.S. Subramaniam, and the celebrated Bijo Emmanuel versus State of Kerala, where he appeared along with Sri Pali Nariman, and where it was argued on the rights and freedoms under Article 25 and Article 19(1)(a) of the Constitution. There are many more cases, but due to paucity of time, I have limited this to the few cases I have referred to. Later, Justice H.R. Khanna invited him to be a member of the Law Commission, and he contributed as a member therein. Apart from his contributions in the public sphere, Justice Iyer was known for his humility, kindness, and compassion. He was a role model for many, and his legacy will continue to inspire generations to come. I thought, having regard to the personality and the life and career of Justice Krishnamoorthy Iyer, I would select a topic on which deals with essentially on the constitutional values and ideals, and I have named it Transformative Constitutionalism and Basic Structure Doctrine, a Dialogue. At a first blush, it may appear to be contradictory, but I have tried to reconcile the two doctrines. The Constitution of India emerged as a culmination of many decades of struggle and anti-colonial rule. Its deeper orientation is in fact historical because it is preceded by the conditions that shaped our Constitution. Societies are not blank slates at the moment of constitutional adoption. They are layered with histories, institutions, discriminations, traditions, and they cannot be just swept away by a new constitution as such. It is having taken note of this caveat that transformation in the Indian context corresponds to two historical legacies of injustice which prevailed prior to the adoption of the Constitution. The first way in which Constitution was transformed was in the relationship between the individual and the state. India became a republic. It was no longer a colonial regime. Apart from universal adult franchise, which is so relevant today, and representative democracy, this transformation was expressed in fundamental rights enforceable against the state. The Indian Constitution was transformative in another sense. It contemplated a thorough reconstruction of the society too. As I already stated, deeply pervasive hierarchies were maintained by structures that took various forms, caste being the principal among them, but also gender, class, race, etc. This recognition is also reflected in the horizontal rights of the fundamental rights. I need not elaborate to this enlightened and erudite audience about Article 15(2), Article 17, and Article 23, which I can just highlight. It is important to also note the genesis of the term transformative constitution. The term has become a part of the constitutional discourse since the making of the Constitution of South Africa in 1996. Incidentally, it is going to complete its 3 decades this year. Perhaps one of the most widely accepted explanation of the term transformative constitutionalism is offered by the American academic Karl Clare in his book titled Legal Culture and Transformative Constitutionalism, where he writes, and I quote, "Transformative constitutionalism connotes an enterprise of inducing large-scale social change through non-violent political processes grounded in law." That is what our Constitution is, was, and shall ever be when we adopted it on 26 November 1949. The dominant approach of interpretation underlying constitutionalism is that it was not meant only for the 1950s, but it is a living tree, so dynamic that it is always evolving with the decades. The living tree approach has been invoked, for instance, to justify the expansive rights under Article 21 or even Article 14 for that matter. Transformative constitutionalism recognizes that the framers were building a constitution meant to last for generations and not for a limited period. We all know as to the vehicles or the organs of the Constitution through which the transformative agenda operates, that is, through the legislature or the parliament, through the executive, and through the courts. The transformative vision of the Constitution of India can be broadly understood through three themes within the Constitution. For paucity of time, I am only concentrating on these. First is the Equality Code contained in Articles 14 to 16 of the Constitution. Second, the Fraternity Code declared most clearly in the preamble. And finally, and third, is the Constitution's Liberty Code in Articles 19 to 22. The Equality Code. The post-colonial Indian state was highly conscious of the necessity to address looming issues such as poverty, illiteracy, untouchability, and gender inequalities. Recognizing the importance of law as a catalyst for social change and the significance of rights in remedying the harsh iniquities of the past, the Constitution has emphasized the importance of universal rights of equality and non-discrimination. Second, fraternity, which is, in addition to the values of liberty and equality, fraternity as a leveling instrument has been clearly stated in the preamble, which will reverse the socialization of biases, discrimination, and power dominance in society. It signals a commitment to a political community in which differences of belief, identity, and practice do not translate into either domination or civic exclusion. Fraternity's constitutional role must be carefully understood. Its force lies not in command, but in orientation. It is a day-to-day practice for all of us. It must preserve the space for persuasion, social change, and democratic deliberation. This is especially significant in order to deepen our democracy and its values. Coming to liberty, it is one of the most elementary goals of transformative constitution, which is to ensure freedom of the individuals. We know about A.K. Gopalan versus the state of Madras and the limited interpretation that was given by the Supreme Court in 1950. But in 1978, in Menaka Gandhi versus Union of India, the court stated that a procedure which meets the mandate of Article 21 was still subject to the challenge under Articles 14 and 19. This broad interpretation has become the starting point, a springboard for a spectacular evolution of law relating to personal liberty in various cases. Meaningful transformation presupposes a robust domain of individual freedom, within which private persons can act, choose, and dissent without justification to the state. The thinning out of personal liberty, often in the name of collective or public interest, must be guarded against. Transformation in this sense presupposes a restraint. This insight directs attention to the constitutional mechanisms that exist precisely to enforce such restraint. Among these, the basic structure doctrine occupies a distinctive place. It is the site at which the Constitution most explicitly articulates limits on the exercise of power, even when the power is claimed in the name of the Constitution itself. The origins of the basic structure doctrine in the Indian context lay in the founding moments and the early years of self-rule. We all know at that time the Parliament was concerned with the reform agenda to abolish the then prevailing zamindari system. Since independence, questions were raised in legal academia and before courts about the scope of the Parliament's power to amend Part 3 of the Constitution, which constitutes the fundamental rights. I need not go into the details of it, but in Shankari Prasad Singh Deo, the Supreme Court said that Article 368 empowers the Parliament to amend the Constitution without any exception, and that the fundamental rights are not excluded from the scope of Article 368. The same position was affirmed in the next case, that is Sajjan Singh. But Justice Mudolkar in Sajjan Singh's case has brought in the famous expression, basic features. He expressed doubt as to whether certain basic features of the Constitution, to which the framers intended to give permanency, could be amended as well. Then what would be left of the eternal values of the Constitution then? He questioned whether such amendment would amount to rewriting the Constitution. The first event in the saga leading up to the formulation of the doctrine occurred in 1967, when the Supreme Court held in Golaknath that the Parliament had no power to alter any of the fundamental rights enumerated in Part 3 of the Constitution, even by way of a constitutional amendment. The Parliament responded to the judgment in Golaknath by amending Article 368 itself, by enacting the Constitution 24th, 25th and 29th Amendment Acts 1971. The Constitution 24th Amendment Act purported to abrogate the rule in the Golaknath case and to restore the power to amend the fundamental rights. Since I am speaking on the soil of Kerala, I thought the controversy with regard to the Keshavananda Bharati case must be highlighted, and therefore I selected this topic. The immediate question before the Supreme Court in Keshavananda Bharati was whether Parliament possessed unlimited authority to amend the Constitution, including the power to alter or abrogate fundamental rights. In resolving this question, the court rejected both extremes. It refused to hold that the Constitution was entirely unamendable. The amending power was recognized, but it equally declined to accept that the amending power was plenary and uncontrolled, so that one day the entire Constitution is amended. Instead, it articulated a structural limitation. While Parliament could amend any part of the Constitution, it could not alter its basic structure. The verdict in Keshavananda Bharati case can be found in 11 separate judgments. But then there was a statement, a seminal concept which was signed by a few of them, called the basic structure of the Constitution, which renders the same immune to amendment by the Parliament. Chief Justice Sikri, who was presiding over the 13-judge bench, identified 5 basic features. First, supremacy of the Constitution. Second, republican and democratic form of government. Third, secular character of the Constitution. Fourth, separation of powers between the legislature, the executive and the judiciary. Fifth, federal character of the Constitution. Justice Shalath and Justice Grover spoke about the unity and integrity of the nation and the importance of the directive principles of state policy. Justices Hegde and Mukherjee identified a separate list of basic features, while Justice Jagan Mohan Reddy spoke about the preamble of the Constitution itself being the basic feature. The Indian judiciary and the polity, as well as constitutional scholarship, to this day are consumed by the magnificent innovations created by the 11 opinions in the historic verdict of Keshavananda Bharati. The many varied and profound questions it raises, the place of judicial review in a democratic society being, according to me, the principal among them. Later, of course, the doctrine was applied and cemented in the case of Minerva Mills, Vaman Rao, S.R. Bommai, where secularism was spoken of, and I.R. Coelho. I do not wish to elaborate on all these judgments, but I must say that from the outset, the basic structured doctrine was conceived by the Indian judiciary as a response to a specific structural anxiety that the judges had then. A written constitution, if fully amendable, risks collapsing into an ordinary statute. We have seen repeal and there being a repeal of statute and reenactment. Sometimes there is only a repeal and there is no reenactment. That cannot happen to a constitution. Yet a constitution that cannot be amended risks obsolescence. Equally significant is the doctrine preserves certain transformative principles such as constitutional supremacy, republicanism, equality before law, and liberty that gives coherence to a constitutional order across time, decades, and centuries. By marking the boundaries of permissible change, the doctrine creates the conditions within which questions about the Constitution's transformative commitments can be meaningfully asked. Thus, according to me, transformative constitutionalism is concerned with how the Constitution works over time. The basic structure doctrine is concerned with how far it can be altered. One speaks the language of aspiration and the other the language of limits. Very simply put, the basic structure tells us what must not be lost. Transformative constitutionalism explains how those commitments are meant to endure. One secures the Constitution against annihilation. The other ensures it does not harden into irrelevance. Today, I propose that transformative constitutionalism and the basic structure doctrine speak to each other in the following ways. There may be many more ways, but I could identify only these. First, the basic structure doctrine identifies the constitutional minimum. It marks those foundational commitments: liberty, equality, dignity, rule of law, constitutional supremacy, and above all, judicial review, without which the Constitution would lose its identity. Its role is essentially negative. It tells us what constitutional change must not destroy. Second, transformative constitutionalism supplies the constitutional trajectory. It explains how those foundational commitments which the basic structure doctrine identifies are meant to operate across time. Its role is dynamic rather than prohibitory. It guides how constitutional values are to be realized, deepened, and made meaningful in practice over decades. Third, when read together, the basic structure doctrine disciplines transformation, and transformative constitutionalism animates the basic structure doctrine. Transformation is constitutionally legitimate only insofar as it advances basic structure values, rather than hollowing them out. At the same time, the basic structure avoids becoming a doctrine of inertia by recognizing that fidelity to constitutional identity may sometimes require change rather than mere preservation. Finally, this dialogue clarifies the limits of both. Transformative constitutionalism cannot be invoked to justify erosion of negative liberty, dilution of habeas corpus, or normalization of coercive power, because these strike at the very restraints the basic structure exists to protect. Equally, the basic structure cannot be invoked to freeze constitutional meaning at the moment of enactment, because a constitution committed to justice cannot be indifferent to the condition of its own application. In short, the basic structure secures the Constitution against destruction. Transformative constitutionalism secures it against moral exhaustion. Together, they describe not a conflict, but a constitutional method of enduring through principled change. The connection between transformative constitutionalism and the basic structure doctrine, therefore, is intellectually coherent. One supplies direction, the other supplies restraint. The question then is not merely whether transformation and structure can be reconciled in principle, but who ensures that transformation does not become destruction and also that structure does not ossify into stagnation. If transformative constitutionalism is to operate within the outer limits applied by the basic structure doctrine, there must surely be a constitutional actor capable of policing those limits. That actor is the judiciary, exercising the power of judicial review. Without judicial review, the basic structure doctrine would be a mere constitutional slogan. Courts, on the other hand, translate abstract commitments, liberty, equality, dignity, the rule of law into actionable claims. Thus, both basic structure doctrine and transformative constitutionalism converge institutionally in the judiciary and its important role. One as a guardian against constitutional self-negation, the other as an engine of principled constitutional development. However, judicial review can discharge this dual function, giving effect to the transformative spirit of the Constitution only if there are two things: separation of powers on the one hand and independence of judiciary on the other hand. First, on separation of powers. The logic of the basic structure doctrine articulated in Keshwananda Bharati assumes that Parliament's amending power is limited and that it is for judiciary to determine when that limit has been crossed. I need not remind this enlightened audience about the case surrounding Indira Nehru Gandhi versus Rajnarayan, where the Parliament attempted to immunize the Prime Minister's election from judicial scrutiny. But the court's ability to strike down that attempt depended entirely on its structural independence from the political branches. This principle was recently affirmed by the Supreme Court in re directions in the matter of demolition of structures. The court was confronted with a troubling practice: the demolition of homes by executive authorities on the mere basis that the occupants stood accused of wrongdoing. The court clarified the constitutional boundaries in clear terms. Determining guilt is a judicial function that would require adjudication on the basis of evidence and adherence to due process. If the executive demolishes a citizen's home merely because an accusation has been made, without trial, without findings, without following legally prescribed procedures, it effectively assumes the role of a judge. That collapses the constitutional scheme. Separation of powers is the architecture that ensures the executive does not adjudicate, the judiciary does not administer, and the legislature does not execute. Where these lines are respected, constitutionalism survives. Where they blur, arbitrariness would trump. Next, equally crucial is that judicial review must be underwritten by judicial independence. Independence secures the capacity of courts to articulate and defend constitutional commitments against transient political whim. Judicial review frequently requires courts to invalidate legislation, restrain executive action, or set aside constitutional amendments enacted by political majorities. These are not easy tasks for the judges or for the courts. They often carry political consequences. Even if judges know that unpopular decisions may cost them elevation, extension, or bring them in the bad books of the powers that be, that should not come in the way of decisions. Ultimately, it is the conviction, courage, and independence of a judge which really matters. We as judges should always follow our oath of office, which is our judicial dharma, and live up to it irrespective of its consequences on our career. The best example we have today is of Justice H.R. Khanna, who was keen to uphold the Constitution during the most difficult period of our history, even at the cost of being overlooked to the highest judicial office in the country. Otherwise, judicial review becomes symbolic, exercised cautiously, selectively, or not at all. I would say, as a result, even judicial accountability would suffer. Let me say that we judges, we should unite for the cause of justice, for we have nothing to lose except our independence. I would repeat this. Let us judges unite in this country for the cause of justice, for we have nothing to lose except our independence. And once we lose our independence, we cease to be judges. There are temptations looming all over, but according to me, the shortest word and the shortest sentence in English language is no, N-O. Whatever be the temptations, just say the word no, and there you are clear in your mind and for all times to come. Security of tenure insulates judges from retaliation. Transparent and structured appointment processes reduce partisan capture. How we appoint our judges, whom we choose as our judges, what is the extent of neutrality the recommended candidates have, these are all very relevant in these days. Institutional autonomy, administrative and financial, prevents indirect nudges of pressure. These safeguards do not make judges infallible, but they make principled adjudication possible. Ultimately, the true content of judicial independence is realized not in institutional design alone, but in the manner in which judges discharge their office. For this, there are two other aspects. First is independence from external influence. A judge must be free from political pressure, institutional intimidation, or popular demand. Second, and more subtly, independence also operates within the judicial institution. It also requires that each judge be free to express his or her considered view of the law, even when that view diverges from colleagues. Separate and dissenting opinions are manifestations of intellectual autonomy. This is independence of the judiciary in its most enlightened form, according to me. If the law, as we understood it, requires clarity, even bluntness, then dilution for the sake of consensus is a form of compromise we should be unwilling to make. In this way, the relationship between transformative constitutionalism and the basic structure doctrine is not merely conceptual, but it is institutional. Their complementarity presupposes judicial review, and judicial review presupposes separation of powers and judicial independence. Strip away judicial review and the doctrine becomes only a slogan, advisory. Only within a framework of separation of powers and judicial independence can transformation remain constitutionally bound. Democracy is dedicated to liberty and equality. Without the judicial protection of individual rights against their encroachment, the preconditions of liberty and equality would fall. It is this arrangement, a transformative vision guided and bounded by the basic structure limits and enforced through independent judicial review within a system of separated powers, that ensures constitutional continuity in the midst of change. In conclusion, I would say it is thus possible to draw a principled connection between transformative constitutionalism and the basic structure doctrine, despite their seemingly divergent orientations and apparent contradiction. Transformative constitutionalism appears aspirational, animated by the promise of deep social change, while the basic structure doctrine appears conservative, concerned with preservation. Amendment, after all, is the mechanism through which a constitution admits change. But if everything can be amended, then nothing is constitutional. The constitution dissolves into ordinary politics then. Transformative constitutionalism gives the constitution a moral and historical trajectory. The basic structure doctrine ensures that this trajectory does not become indistinguishable from rupture. Together, they reflect a constitutional imagination that accepts change as necessary, but not limitless. An imagination that recognizes that transformation without structure risks arbitrariness, just as structure without transformation risks stagnation. On that note, I conclude my lecture. I thank you all for your kind attention. But before I actually conclude, I must say that I am happy to inaugurate the program of continuing legal education, which has been taken up by the Bar Association. I commend your efforts in instituting the continuing legal education program, which plays a vital role in strengthening the bar's engagement with complex legal issues in various emerging areas of law. In a rapidly evolving legal landscape, whether it's in insolvency, bankruptcy, restructuring of companies, maritime law, intellectual property, or other specialized fields, continuous learning is very essential. Such initiatives not only enhance professional competence, but also ensure that as practitioners of law, you remain equipped to address sophisticated legal problems with clarity and depth. We as judges are always looking for clarity in submissions and citing of correct provisions of law, and not be blown away by the AI. At the same time, the nuanced use of artificial intelligence must be thought of by the bar associations. What methods you would have to see that the judgments which are cited or the positions of law which are cited are correct and true. That instead of citing the provisions and sections of the Act, the commentaries are not cited as taken from the AI. We all know earlier, as advocates, we did not have all these facilities. To search for a judgment, we would go for the Quinquennial Digest, AR Manual, or the Supreme Court Digest. Now, by a click of a button, if you click one word, you will get 100 decisions. Now, how are you going to cite all that? It becomes it becomes totally impractical. Therefore, I would say that please go to the read and read and read every provision of law that you are citing or you are advancing, because every time you read a provision of law, you would get a new insight. I am getting new insights in the Supreme Court on CPC, which I have been studying for almost 40 years. So therefore, I would advise and suggest to our young friends and advocates to read the provision of law every time you have a case. Read the commentaries on it. We have very great commentators of law which are time tested, and therefore you must read the commentaries on the provisions, dissect the provisions, then go to the case law and to the correct case law and not to imaginative case law, and cross-check that there is such a citation in the reputed legal journals such as the AAR, SEC, and what have you, and thereafterwards cite the judgments before the courts. Otherwise, there is an additional burden on us judges that whenever cases are cited in the law courts, we have to ask somebody to see whether those judgments really exist, whether those quotations really exist, because in Supreme Court, we have had personal experiences where judgments cited do not exist, and where quotations from Supreme Court judgments do not exist. Therefore, I request the President of the Bar to have a separate discussion on the use of AI in practice and to best assist the courts with the help of AI. I thank you all for your kind attention. I hope I have not tested your patience. Thank you once again to Mr. Balaji Murthy and his family. I thank the Kerala Bar Association for inviting me. And last but not the least, I thank Honorable Chief Justice and each one of you for your kind attention. Thank you and namaskar.
Thank you so much, Your Ladyship, for that masterful dialogue and for those profound insights. To conclude this formal session, I call upon Sri Balaji K. Murthy for the vote of thanks.
The chief guest of this evening, Honorable Justice B.V. Nagarathna, Chief Justice of the High Court of Kerala, Honorable Justice Soumen, Honorable Judges of the High Court of Kerala, distinguished retired judges of the Supreme Court of India and the High Court of Kerala, respected Advocate General of the High Court of Kerala, Sri K. Gopalakrishna Kurup, President of the Kerala High Court Advocates Association, Sri Piyus Kottam, Secretary of the Kerala High Court Advocates Association, Advocate Nima Jacob, senior advocates, and members of the legal fraternity, members of the press, well-wishers, friends, and my dear family members. What an honor it is for my family, friends, and myself to be present in this distinguished and august gathering, and that too in the venerable precincts of the High Court of Kerala. Permit me to let you know that I am not from the legal fraternity, and therefore, please do pardon me if I am out of step with the practices, customs, and protocols. I can assure you that it is purely out of ignorance than intention. May I take this opportunity to pay homage to my parents, my elder brothers, my uncle, Justice Padmanabhan, and my cousin brother, Justice S. Shankarasubban, who was a judge of this very High Court. Honorable Justice Nagarathna, ma'am, I can't even find adequate words to express our sincere thanks and gratitude to you for kindly accepting to be the chief guest of this evening. Not only were we all very keen, but it has always been our ardent desire that you should deliver the Justice TSK Memorial Oration this year. After sending you the mail request, I spent many days in prayers till one day the reply came that you would indeed consider our request favorably. And not just that, you also so kindly acceded to the last-minute request of the Kerala High Court Advocates Association to inaugurate the continuing legal education program. Ma'am, your gentle and kind demeanor, your genuineness and simplicity, and your affection and kind words each and every time that we spoke have made Usha and me a great fans of yours. We really can't thank you enough. Ma'am, as a token of our affection and appreciation, please permit us to present you with a memento to remember us by. It is nothing but just a book and a shawl. At the last oration, my elder brother, Shankar, a doyen of the Indian and international maritime industry, was by my side as a pillar of strength. May I now request his wife and Justice TSK's daughter-in-law, Geeta Shankar, an internationally acclaimed yoga exponent who was conferred the title Yoga Chikitsa Acharya by the Government of India, and who is the registrar of the KYM Institute of Yoga Studies in Chennai, to kindly come up and present the memento to Honorable Justice Nagarathna. When I'm scrolling my phone, my hands are shivering. Honorable Justice Soumen Sensor, you were sworn in as Chief Justice of the High Court of Kerala on the 10th of January this year. I sent you a mail on the 12th of January requesting for an appointment to meet you and to request you to preside over this evening's program. On the 22nd of January, late afternoon at 4:20 p.m., I was seated before you. What can I really say than that all the gods were with me and guiding me? Sir, we thank you immensely for kindly agreeing to preside over this oration and also inaugurate the Wednesday Club. Sir, may I request you to kindly accept a memento as a token of our love and affection. May I request Justice TSK's youngest daughter-in-law, Usha Balaji Murthy, a stalwart from the insurance industry, a chef par excellence, and a fantastic discipliner and manager of a husband, to kindly do the honors. Galaxy of honorable judges of the High Court of Kerala, your presence here this evening means a whole world to us. I honestly have no idea how to express our sincere gratitude to you other than to say a big thank you to each and every one of you from the bottom of our hearts. Respected and distinguished former judges of the Supreme Court of India and the High Court of Kerala, your mere presence means a lot to us and added so much of value to this evening's program. That you have taken the time out and you're with us means a whole world to us. We bow our heads in gratitude to each and every one of you. Respected Advocate General of Kerala, Sri K. Gopalakrishna Kurup, Sir, your kindness and gentle demeanor over the last 3 years that I have known you has never failed to charm me. Sir, we can't thank you enough for so kindly rendering the felicitations of Justice TSK. Sir, may I request you to kindly receive our memento from Anupama Gopal, a highly acclaimed fitness expert and a marketing guru and granddaughter of Justice TSK. Respected President of the Kerala Advocates Association, Sri P.S. Kottam, what a pleasure it has been to know you and interact with you. What struck me about you is your passion for not just the welfare of the members of your association, but the upliftment of the weaker members of your association, particularly the young advocates, and even more particularly, the very challenged and needy ones. Sir, may all your dreams come true and all your efforts successful. I want to assure you that I shall be only too happy to render whatever support I can within my means and my capability. May I request Sunil Krishnamoorthy Shankar, Managing Director, TAG India, an internationally reputed advertising and branding company, and grandson of Justice TSK, to kindly step up and do the honors. Secretary of the Kerala High Court Advocates Association, Advocate Nima Jacob. Ma'am, I know that in any association, the secretary's job is always the thankless and tough one. All of us are sure that you will rise up to the occasion and successfully execute the dreams and vision of your association. May I request Sindhu Surendran, a highly reputed educationist, academic counselor, and economics wizard of a highly reputed school, KC High in Chennai, and granddaughter-in-law of Justice TSK, to kindly do the honors. Distinguished senior advocates, and members of the legal fraternity, no words will suffice to express our sincere thanks and gratitude to each and every one of you for being present here. We are truly energized and encouraged by your presence this evening, and we shall always cherish these wonderful moments. Roy Chaco and Romy Chaco, what can I say? The Chaco family and the TSK family have been like one. The friendship, the bonhomie, and the love has stood the test of time for over 6 decades and more. You both have been with me every single step of the way, always supporting me, always encouraging me, rapping me on my knuckles when I needed one. Surely, this dream of Justice TSK Oration would have remained a pipe dream but for your support and encouragement. May I request Krishna Balaji Murthy, a distinguished young lawyer of the Bombay High Court and a partner in the highly acclaimed law firm Vadia Gandhi, and youngest grandson of Justice TSK, to kindly do the honors to both Roy Chaco and Romy Chaco. Romy, I know you're hiding somewhere. Krishna, I think you need to remain. For any event to be successful, there are always unseen faces who bear the brunt of the work. Advocates Mary Shalini is one such. And of course, Advocate Danny Davis and Advocate Renoy Vincent for emceeing this evening so beautifully and so wonderfully well. May I request Krishna Balaji Murthy to kindly do the honors to Advocate Mary Shalini, Advocate Danny Davis, and Advocate Renoy Vincent. Members of the press, no function and no event can be a success without your presence and your support. Thank you so much for being with us this evening and for your coverage. Last but not the least, our dear friends who have traveled from far, thank you ever so much for being with us. We are deeply touched by your love and affection. A big thank you to Sri Rashid of LiveLaw, who are so kindly beaming this event live. Last but not the least, I must mention this. At the last memorial oration, I announced 2 scholarships, the Justice T.S. Krishnamoorthy Iyer Scholarship and the Justice K. Shankara Subbayar Scholarship, for 5 financially challenged girl law students and 5 male law students. On discussion with the then association, we realized that the need was far more for bright but young and struggling first generation advocates. We identified 10 such deserving persons and distributed an amount of 25,000 rupees each, totaling to 2.5 lakhs as fellowships. I am in talks with the current president of the Kerala High Court Advocates Association, and let me assure you, we will continue to extend our support within our means and on the recommendation, as the needs this year, I believe, are different. And finally, thank you all for your patience. Wishing you all a good evening, good luck, and Godspeed. Happy Holi. God bless.
Thank you, sir, for your words of your gratitude. This brings us to the close of today's formal session. We invite everyone to join us for the high tea. Thank you for being with us this evening. Thank you all.